Did you know that harassment does not have to be of a sexual nature, but can include offensive remarks about a person's sex? For instance, sexual harassment can include unwelcome sexual advances, requests for sexual favors, and anything verbal or physical of a sexual nature. Sexual harassment falls within a larger umbrella known as sexual misconduct. Under the umbrella of sexual misconduct, any unwelcome conduct of a sexual nature committed against an individual without consent is considered harassment. Within this umbrella, sexual misconduct includes sexual harassment, stalking, domestic violence, dating violence, and hate crimes. Harassment becomes a real problem when it's so frequent or severe that it creates a hostile or offensive work environment, or when it results in an adverse employment decision, such as the employee being demoted or possibly fired. Remember, the harasser can be a supervisor, a co-worker, a client, or customer. This training will discuss the laws that surround sexual harassment and how to investigate complaints. It'll include the protected categories, which were enforced by the US Equal Employment Opportunity Commission, or EEOC. The laws enforced by the EEOC make it unlawful to discriminate against employees and job applicants on the basis of race, religion, color, sex, national origin, disability, or age. This training will outline sexual harassment in the workplace, providing examples of what this may look like, while also defining consent. Further information will be provided on the laws governing sexual harassment and policy guidance relevant to investigating complaints and how to handle them. Are you ready to jump in and learn more about how to protect yourself and your employees from the harms of sexual misconduct and sexual harassment? Let's go. At this point in the training, you have a baseline understanding of what sexual harassment means. But what are some examples of this in the workplace? Sexual harassment can encompass a wide range of conduct. So let's take a look at a few examples. Any physical assault or attempt at physical conduct of a sexual nature, which includes touching, pinching, grabbing, rubbing up against another's body, all done without consent, is considered prohibited conduct. Unwelcome sexual advances or comments, noises, remarks, or jokes about a person's sexuality or sexual experience is considered prohibited conduct. Preferential treatment towards an employee in exchange for sexual favors is considered prohibited conduct. Subjecting, or threats of such, an employee to unwelcome sexual attention or conduct, or intentionally making performance of the employee's job more difficult because of that employee's sex is considered prohibited conduct. Sexual or discriminatory displays anywhere in the workplace is considered prohibited conduct. Let's consider two types of workplace sexual harassment more closely. The first type is called hostile work environment sexual harassment. This can occur if the employer provides less favorable conditions of employment to an individual that are different from another sex co-worker, simply because of the individual's gender status. Another form of hostile work environment sexual harassment can occur when someone makes an individual the target of unwelcome, sexually suggestive or demeaning comments, offensive gestures, jokes, intimidating behavior, or pornographic materials. The second type of workplace sexual harassment is referred to as quid pro quo sexual harassment. This type of harassment occurs when a supervisor asks or demands sexual contact from an individual in return for employment benefits or promotions. Both types of harassment are prohibited if the individual has not consented to or agreed to the behavior. If someone feels embarrassed or afraid to say no because of fear of losing employment or being punished at work, this could be a form of harassment. Now let's discuss consent and how it's defined. Consent is defined as informed, actively and freely given mutually understandable words or actions that indicate willingness to participate in a mutually agreed upon sexual activity. Consent cannot be given by individuals who are minors or underage, intoxicated or incapacitated by drugs or alcohol, asleep or unconscious. Consent must be given freely and willingly. It's estimated that over 70% of females will experience sexual harassment during their careers. Because of this astounding statistic, companies lose millions of dollars every year due to lawsuits and a loss of productivity resulting from sexual harassment. Most victims of sexual harassment leave their place of employment and take new jobs within 2 years. You may find yourself asking, is it considered illegal to make offensive comments about a person or to simply tease someone? The answer is, sexual harassment can include unwelcome sexual advances, requests for sexual favors, and any other verbal or physical harassment of a sexual nature. Even if the harassment is not of a sexual nature, it can include offensive remarks about a person's sex. Harassment becomes illegal when it's so frequent or severe that it creates a hostile or offensive work environment, or results in an adverse employment outcome, such as the victim being demoted or fired. The harasser can be the victim's supervisor, a supervisor in another area, a co-worker, or even a client or customer. There are laws that govern and protect an individual's safety, and it becomes extremely helpful if the victim informs the harasser directly that the conduct is unwelcome and must stop. The EEOC looks at the whole record when investigating allegations of sexual harassment. They investigate the circumstances, nature of the sexual advances, and the context in which the alleged incident occurred. The law also states that it's unlawful to retaliate against an individual for opposing employment practices that discriminate based on sex. Under Title VII, sexual harassment is a violation of Section 703 of Title VII. Under Title VII, an employer's liability for workplace sexual harassment depends on what the status is of the harasser. If the harasser's a supervisor, the employer has vicarious liability for workplace sexual harassment. However, if the harasser is a co-worker or non-employee, the employer is liable for workplace sexual harassment under a negligence standard. As an employer, you must adopt written sexual harassment reporting policies. These policies need to mandate that victims of workplace sexual harassment have to report it to management HR employees. Failure to report opens the door for the employer to raise this affirmative defense to liability and damages. An employee's fear of confrontation or retaliation does not alleviate him or her from alerting the employer to a hostile work environment. In the next section, we'll discuss policy guidance for reporting sexual harassment. We'll discuss retaliation claims for reporting sexual harassment, time limits of filing a claim, and responding in conduct to violation of policy. Now let's take a deep dive into policy guidance that relates directly to sexual harassment. In 1980, the EEOC issued guidelines declaring sexual harassment a violation of Section 703 of Title VII. This established criteria for determining when unwelcome conduct of a sexual nature constitutes sexual harassment, defining the circumstances under which an employee may be held liable, and suggesting affirmative steps an employer should take to prevent sexual harassment. Title VII does not condemn all conduct of a sexual nature in the workplace. Therefore, employers must clearly define sexual harassment and how they will handle such claims. It can be challenging to distinguish between invited, uninvited but welcome, tolerated, and flatly rejected sexual advances. This is generally because sexual attraction plays many roles in the day-to-day social exchanges between employees. This distinction, however, becomes extremely critical because sexual conduct becomes unlawful only when it's unwelcome. The EEOC recognizes that victims may fear retaliation or repercussions from complaining about the harassment, and that such fear may be the reason there is a delay in opposing the conduct. We will talk more about retaliation in a few moments. But firstly, let's look at liability of unlawful harassment by supervisors. Liability for unlawful harassment by supervisors maintains that an employee is a supervisor if the employer has empowered that employee to take tangible employment action against the victim. For instance, a significant change in employment status, such as hiring, firing, failing to promote, or reassignment with different responsibilities. The employer must maintain liability for harassment by a supervisor on a prohibited basis that culminates in a tangible employment action. No affirmative defense is available in such cases. Within policy guidance related to sexual harassment are retaliation claims for reporting. The EEOC deems retaliation illegal, regardless of whether the claim was true, if the employee made the claim in good faith. You may be asking yourself, what does this mean? This means an employee isn't legally justified to commit retaliation just because sexual harassment never really occurred in the workplace. Retaliation is bad for business. It's within the employee's best interest to make employees feel comfortable and safe reporting discrimination, so they can investigate and handle any conduct that violates the law or company policy. To prevent any form of retaliation from occurring, employers must inform all employees that retaliation is prohibited. Employers should ensure employees that they will not be punished for taking actions that are protected by law. Ensure managers understand their responsibility to stop, address, and prevent retaliation, and to hold employees accountable for complying with and enforcing discrimination rules and policies. Want some tips for preventing retaliation within your organization? Be sure you fully understand your responsibilities. Don't take out any frustrations about the complaint on the employee. Treat employees consistently. Explain the rules and expectations to all employees. Inform them retaliation's illegal and won't be tolerated. Always encourage employees to share with you any concerns about discrimination. Respond to their complaints, concerns, or questions promptly. And don't forget, hold employees accountable. In addition to understanding your responsibility towards retaliation, as an employer, you also need to understand the statute of limitations for filing Title VII claims, including sexual harassment. The EEOC sets the statute of limitations of 180 days for filing such claims. Some states maintain separate sexual harassment laws protecting employees. In this case, the time limit to file a claim becomes 300 days. So you should file sooner than later, as the time limits for filing a charge with the EEOC will not be extended while you attempt to resolve a dispute through another forum. Other forums for resolution can be pursued at the same time as the processing of the EEOC charge. Examples of other forums include a union grievance and arbitration or mediation before filing a charge with EEOC. What do you do if a policy has been violated? The first step in dealing with any policy violations is to have direct and honest communication with the employee. This conversation needs to happen immediately upon learning a policy has been violated. Your role is to let employees and others know that this is a very serious and important matter and that any violations won't be tolerated. The next step is to involve others if necessary. This can be your supervisor, human resources, or legal department. You need to be sure you follow the proper procedures and protocols for escalating or reporting the violation and seek guidance and support from relevant parties. You also want to keep the violator informed of the process and the outcome, while respecting their privacy and confidentiality. The final step is to document the process and the outcome of addressing the violation. You'll need to record the violation and all details, all communication, the involvement of others, the actions taken, and the results or feedback. You'll also need to review and update the policy if needed, and communicate any changes or clarifications to the respective stakeholders. Understanding sexual harassment policies, the US Equal Employment Opportunity Commission's laws governing a victim's rights, as well as the employer's responsibilities, code of federal regulations, and policy guidance related to harassment is critical in understanding sexual harassment, protected categories, and how to handle such complaints. As you become more aware of how to investigate complaints and how to respond, it can be applied to your workplace culture. You'll be better equipped to handle potential complaints should they arise, and learn how to respond in a timely manner. Overall, culture is created through leadership. Employers need the proper training to get more people involved in solving the problem. Leaders must take responsibility for the problem and commit to solving these issues, setting an example for all managers and supervisors. I hope you found this training to be helpful in the development and growth of your individuals, teams, and organizations. Understanding sexual harassment, victims' rights, and the employer's responsibility will help keep your individuals and teams safe from unwanted harassment. This starts with you.